नमस्कार दोस्तों, मेरा नाम श्रीनिवास एडवोकेट है। जिस विषय पे मैं अभी बात कर रहा हूँ वो विषय है मेंटेनेंस awarded by court under 125 CRPC. If maintenance is ordered under 125 CRPC for wife and children, and whether the salary can be attached of husband, yes, the salary of husband can be attached as per the attachment which has to be done. The court can attach the salary under section 421 of CRPC. If 421 section is to be invoked, the clause B of subsection 1 of section 421, the salary can be attached, and the defaulting husband has to be attached before it reaches his hand. The provisions of clause B of subsection 1 of 421 have to be followed, and not to clause A of subsection 1, as it is not easy to see how the salary of a person which is about to fall due can be considered movable property in the usual accepted sense. That is a procedure which has to be followed. Attachment of salary 421 CRPC has to be invoked, and the salary can be attached. A letter from the court can be communicated to the concerned department, and the salary can be attached under 421 CRPC when the maintenance is awarded to the wife and children. Now, another subject which is very much important in this is about 126. If ex parte is about passed in a maintenance case, whether ex parte can be set aside by filing a petition. Yes, there is a provision under 126 CRPC, the clause 2, which says all evidence in such proceedings shall be taken in the presence of person against whom an order for payment of maintenance proposed to be made, or when his personal attendance is dispensed with in the presence of his pleader, and shall be recorded in the manner prescribed for summoning cases. So this says, provided that if the magistrate is satisfied that the person against whom an order for payment of maintenance is proposed to be made is willfully avoiding service or willfully neglecting to attend the court, the magistrate may proceed to hear and determine the case ex parte, and any order so made may be set aside for good cause shown on an application made within 3 months from the date of such order. This is the clause under 126 subclause 2. If ex parte order is passed in a maintenance case, the respondent can file a petition for setting aside the ex parte order, and it says that if a proceeding is disposed of ex parte, and if the respondent comes to know that an ex parte order has been obtained against him, the proper legal course open to him is to appear in the maintenance application applied to the court for setting aside the ex parte decree order, on the ground either that he did not willfully avoid service or did not willfully neglect to attend the court. If the cause shown by the husband is good or sufficient, the magistrate may set aside the ex parte order and permit the husband to appear and contest the proceeding. This is the thing. Another thing is whether with regard to limitation, and as already I told you under 126 subclause 2, under provision of 126 subclause 2, an ex parte order can be set aside for good cause. Application is made within 3 months from the date of thereof. One view is that it cannot be said that the period of 3 months mentioned in the provision means 3 months from the date of the knowledge of the order. There is no reason why the section should be read with the word knowledge, which is not there. The other view is that the limitation to set aside an ex parte order is 3 months from the date of knowledge of the order. However, Section 5 Limitation Act may be invoked for condoning the delay. This is the point. So, under 125 CRPC, if husband is not paying the maintenance, he is avoiding to pay the maintenance as awarded by the court, the proper recourse is to go for attachment against his salary, and a petition has to be filed under 421 CRPC. The salary can be attached, and with regard to ex parte of the maintenance, if ex parte is been ordered, the respondent can file a petition saying that due to some reason he could not appear before the court because he could not get served the summons, or due to a reasonable cause, the court can allow the petition, but the cause is it should be filed within 3 months from the date of order, or his knowledge, or else section 5 has to be invoked and limitation act he can file a petition for condoning the delay of such filing petition. मेरा नाम श्रीनिवास एडवोकेट है. अगर मेरा वीडियो पसंद आए तो लाइक कीजिए, शेयर कीजिए. आज का जो विषय था वो 125 CRPC अबाउट अटैचमेंट ऑफ सैलरी एंड it is with regard to 126 CRPC about ex parte order, how to set aside such order and what is the limitation for filing such petition. धन्यवाद दोस्तों for watching this video. वीडियो शेयर कीजिए, लाइक कीजिए, सब्सक्राइब कीजिए. धन्यवाद.